Imagine the quiet hum of a suburban street just before dawn on August 29th, 1993. Now, picture thick, acrid smoke pouring from a family home. Inside, the silence is shattered by a horrific discovery. Stephen and Helen Gilham and their older son, Christopher, brutally murdered, their bodies consumed by a deliberate fire.
A truly shocking scene.
Found nearby, disoriented but seemingly unharmed, is the younger son, Jeffrey Gilham. His story is, well, it's shocking. Woken by his mother's frantic call, he says he ran to the house, found Christopher standing over their mother, heard him confess to killing their parents, watched him light a match, and then, in a blinding rage, chased Christopher downstairs and stabbed him repeatedly.
So the narrative immediately presented as, a son battling a monster brother, a hero arriving too late.
Exactly. But what if that entire narrative was a calculated lie? What if the true killer was the sole survivor, staging a scene to deflect blame? This isn't just a gut-wrenching true crime story. It's a legal marathon that stretched across 2 decades, testing the very foundations of justice and serving as a chilling, vital cautionary tale for anyone who practices or aspires to practice law, particularly as a barrister.
It's a case that really pulls back the curtain on how the justice system grapples with layers of tragedy, conflicting evidence, and the immense pressure to find truth years after the fact. It forces a hard look at things we often take for granted, like what constitutes an acquittal, the true meaning of double jeopardy, and the ethical obligations placed on legal professionals, especially those prosecuting serious crimes.
Absolutely. Today, you're with us for a deep dive into the Jeffrey Gilham case. We've immersed ourselves in the court judgments, legal analyses, and reports that chronicle this extraordinary journey.
Yeah, there's a lot to unpack here.
Our mission is to guide you through the initial horror, the long, winding road of investigations, the unprecedented legal battles over procedural rights and the right to a trial after such delay, the dramatic courtroom clashes, the appeals that expose critical flaws, and the, well, unexpected conclusion.
You'll see how the pursuit of truth collided with the need for finality, how expert evidence became both central and contentious, and why this entire saga is, frankly, compulsory study for any lawyer.
It's a stark reminder of the human element within the rigid structures of the law and how missteps, even, unintentional ones, can have devastating, decades-long consequences.
Definitely.
Let's start right there with that scene discovered on the morning of August 29th, 1993. Describe what the initial responders found.
It was just a scene of utter devastation. On the upper level of the Gilham family home, in the main bedroom and the lounge room, were the bodies of Stephen and Helen Gilham. They had suffered an extreme number of stab wounds. Over 50 wounds in total between them. And a fire had been deliberately set on this level, causing significant damage. Then, downstairs, in the billiard room, was the body of their older son, Christopher Gilham. He had 17 stab wounds, primarily concentrated in the chest.
And importantly,
Significantly, his body was unaffected by the fire. That indicated he was likely killed before the fire really took hold or reached that area. A knife was found near his body as well.
and the narrative that first emerged, shaping the initial police response, came from Jeffrey Gilham, the younger son, found near the house. What was his account of that night?
Jeffrey told police he was asleep in a converted boat shed located about 50 to 70 meters away from the main house. He claimed he was woken by a frantic call from his mother via an intercom system connecting the boat shed to the house.
Okay.
He ran to the house, entering through sliding glass doors. He described seeing his brother Christopher standing over their mother in the lounge room, whom he presumed was already dead. He said Christopher confessed, stating, "I've killed Mom and Dad."
Wow.
Jeffrey claimed he then watched Christopher light a match and ignite his mother's body, causing the fire to spread rapidly. He saw his father's body also on fire in the bedroom. According to Jeffrey, he grabbed a knife he found nearby, chased Christopher downstairs in a provoked rage, and stabbed him multiple times.
And then?
He claimed he then attempted to return upstairs to help, but was blocked by the intense fire.
And based largely on this dramatic first-hand account, the police initially accepted Jeffrey's version, framing it as Christopher being the initial aggressor, murdering his parents, and Jeffrey acting under extreme provocation when he killed Christopher.
That initial framing is so critical, isn't it? Because it immediately set the direction for the investigation, making it much harder to challenge later. It's a lesson right there about the power of the first narrative presented in a complex scene.
Absolutely. Let's introduce the people who were central to this tragedy and the decades-long legal battle that followed.
Okay, so at the heart of it, the victims, Stephen and Helen Gilham, described by those who knew them, like Stephen's brother Tony, as loving parents, killed with unimaginable ferocity.
Just awful.
And Christopher Gilham, the older son, initially portrayed as the monster. But for his Uncle Tony, he was a gentle, quiet soul, a description that clashed violently with Jeffrey's account and sparked a profound doubt from the very start.
And the sole survivor, Jeffrey Gilham, the younger son, whose story became the central piece of this puzzle. His demeanor in the aftermath became a point of scrutiny for some reports of his composure and seemingly quick recovery, sitting uneasily with the horror he claimed to have witnessed and participated in. He was the one who would later face the accusation of murdering his parents as well.
Then there's the figure whose relentless pursuit drove the case forward for so many years. Tony Gilham, Stephen's brother, and the uncle of Jeffrey and Christopher.
A key player.
Absolutely crucial. From the moment he heard Jeffrey's story, Tony was consumed by doubt. He knew Christopher. The idea of him committing such a frenzied, brutal attack on his parents felt utterly impossible to him. He questioned everything, the sheer number of wounds, the lack of any warning signs, the specifics of Jeffrey's timeline.
He just couldn't reconcile it.
No. Tony became absolutely convinced that Jeffrey had killed all three, staging the scene to frame Christopher. His quiet, unwavering determination, his refusal to accept the official narrative, even wearing Christopher's fencing medal as a kind of talisman, a tangible reminder of his mission. It kept the possibility of a different truth alive when the legal system had seemingly moved on.
The legal arena saw a number of key players step into this unfolding drama, too.
Yeah, on the prosecution side, for the first murder trial against Jeffrey for his parents' deaths, you had Mark Tedeschi, QC. He's a highly experienced Crown prosecutor known for handling major cases.
It's a big name.
Yes, but it's notable that his approach in this and other cases would later be critically reviewed by appellate judges who described it, in some instances, as impermissibly straining for a conviction. That's quite a strong statement from an appeal court.
It is indeed. And for the second trial.
The second murder trial for the parents saw Margaret Canine lead the prosecution. She was described as having a crisp, focused style, shifting the emphasis away from motive like greed, which Tedeschi had touched on, towards timeline inconsistencies and the forensic evidence suggesting a single killer. Throughout these later stages, the Crown was represented by the Solicitor for Public Prosecutions.
And the defense team representing Jeffrey Gilham faced the monumental task of defending against charges brought years after the events.
That's right. Paladin Law, Paladi Ltd., acted as solicitors throughout much of this, instructing various barristers at different stages. In the initial challenges against bringing the case to trial, P. Bolden, SC, and S. Buchan were key defense counsel. Then later, C. Stern, SC, and P. Barham took on the defense representation for the second trial and the crucial appeal. They faced a really tough job given the delay and the nature of the case.
We also have the judges whose decisions were pivotal in shaping this case.
Yes. Justice Howie presided over the initial application to stop the trial and both murder trials that followed. He made critical rulings on evidence, admissibility, and legal procedure throughout.
So he was central to the trial process.
Very much so. And then on the appellate benches, Chief Justice James Spiegelman led the 5-judge panel that heard the appeal against Justice Howie's decision to allow the trial to proceed. The fact they convened 5 judges highlights the complexity and importance of the legal principles at stake.
And the investigators and experts, they played huge roles.
Oh, absolutely. Detective Hans Rupp led the cold case reinvestigation that unearthed new perspectives. Then you have this whole array of forensic experts whose interpretations of the scene, the bodies, and the fire became central to the debate.
Different experts, different opinions.
Exactly. Pathologists like Dr. Kalla and Dr. Lawrence, wound pattern analysts like Dr. Culliford and the later crucial Professor Cordner, fire investigators like Mr. Monday, and carbon monoxide experts like Professor Penny. Their differing opinions on seemingly objective evidence would become a major battleground.
And let's not forget the civilian witnesses and first responders.
No, their accounts of that night, years later, were put under the microscope. Neighbors, friends like Ms. Moscows and Mr. Elton, academics like Professor O'Loughlin, firefighters like Officer Pelham, their recollections were all scrutinized.
Okay, so with these figures in place, let's trace the truly unusual procedural path this case took because it reveals some of the most compelling cautionary lessons for lawyers.
Right. So immediately after the murders in August 1993, based on Jeffrey's account, police charged him with the murder of his brother Christopher.
Just Christopher initially.
Just Christopher. It was during this initial investigation that Jeffrey provided his detailed version of events in an electronically recorded interview known as an AIR-SP and participated in a walkthrough video at the scene. This interview became the foundation of his defense narrative, but it was also later challenged legally.
Ah, okay. On what grounds?
Well, years later, the defense argued these recordings should be excluded because there were technical illegalities in Jeffrey's detention during parts of the interview and the walkthrough. Essentially, his detention extended beyond the lawful limits before being brought before justice.
So a procedural error.
A technical one, yes.
Right.
However, when Justice Howie ruled on this challenge before the trial, he refused to exclude the evidence. He found the illegality was technical and unintentional. The police believed they were acting lawfully based on instructions they'd received. And crucially, he felt it didn't unfairly affect the content or voluntariness of Jeffrey's statements. Jeffrey had appeared willing to cooperate.
So the judge balanced the error against the evidence's importance?
It's exactly. Justice Howie balanced the technical breach against the high probative value of Jeffrey's detailed account, which was essential to understanding his defense, and decided it should go before the jury. It's a reminder that even seemingly minor procedural errors in the initial stages can be litigated intensely years down the track.
Then came a pivotal moment in April 1995, the plea bargain regarding Christopher's death.
This was a critical step. Jeffrey pleaded guilty to the manslaughter of Christopher. Now, the basis for this plea, which the Crown accepted, was provocation specifically that he killed his brother because Christopher had just killed their parents.
Okay, that's the key framing.
It is, and the legal phrasing here is also key. The Crown accepted this plea in full discharge of the indictment for murder of Christopher.
So he wasn't tried for Christopher's murder. He pleaded guilty to the lesser charge of manslaughter based on the idea that Christopher was the initial killer of the parents.
Precisely. And the significance for the later legal battles regarding his parents' deaths cannot be overstated. As the courts later clarified, this was not an acquittal by a jury on the murder charge for Christopher. And crucially, Jeffrey was never formally charged or put in jeopardy of being convicted for his parents' murders in this particular proceeding.
Why did the Crown accept the plea then?
The Crown accepted the manslaughter plea because at that time they assessed they were unable to disprove the alleged provocation, meaning they couldn't prove beyond reasonable doubt that Christopher hadn't killed the parents to defeat that specific defense for Christopher's killing.
Right, so it wasn't a positive finding of fact about who killed the parents.
Exactly. It was more an acknowledgement of the limitations of the evidence then available to the prosecution to rebut Jeffrey's specific defense to the murder of his brother.
Okay, so while it resolved the charge regarding Christopher's death, it didn't legally resolve the question of who killed the parents. This understanding was further cemented by the first coronial inquest, wasn't it?
Yes. In June 1995, the coroner conducted an inquest into the deaths and found that Stephen and Helen were killed by Christopher. This official finding aligned with Jeffrey's account and the basis of his plea.
So at that point, it really looked like the case was closed.
For many people, and seemingly for the legal system at this juncture, yes. It appeared resolved. Jeffrey had faced consequences for his brother's death, and the official findings supported his claim about his parents' killer. Jeffrey moved on, building a new life, presumably believing this horrific chapter was behind him.
But not everyone accepted that narrative, particularly his uncle Tony.
No, Tony's doubt never faded. His gut feeling that Christopher, the nephew he knew, wasn't capable of such monstrous acts, combined with his questioning of the details of Jeffrey's story, fueled a quiet but relentless personal investigation. He continued gathering information, talking to people, nursing his profound conviction that Jeffrey had killed all three.
That determination.
This personal mission, this determination to clear Christopher's name, became the spark that would eventually reignite the legal process years later. It's a powerful example of how an individual's persistent pursuit of truth can challenge the official narrative, even years after the fact.
The case then entered a period of dormancy, legally speaking.
For several years after 1995, there was little official activity. Family relations remained deeply strained, and some media attention kept the case in the public eye. A 1997 TV program raised family concerns, for instance. But legally, it was quiet. That changed around 1999.
What happened then?
Likely spurred by the persistent concerns from family members like Tony, the NSW police initiated a second investigation. This led to a referral back to the coroner's court.
And the second coronial inquest in 2000 proved to be a significant turning point.
It was. The deputy state coroner, after reviewing the evidence, terminated the inquest early. Why? Because they found there was now evidence capable of satisfying a jury that a known person, Jeffrey Gilham, had committed an indictable offense, specifically the murder of his parents.
Wow, a complete turnaround from the first inquest.
A major turnaround. The coroner sent the depositions to the director of public prosecutions. This is the first time an official legal process pointed the finger directly at Jeffrey for his parents' deaths.
Yet, even with this finding, the DPP initially decided not to prosecute Jeffrey for the parents' murders. Why?
That's correct, and it's a crucial part of the procedural history. In both 2000 and again after a further review in 2001, the DPP concluded that, based on the evidence then available, there was still no reasonable prospect of conviction for the murders of Stephen and Helen Gilham.
So they felt they couldn't meet the burden of proof.
Essentially, yes. These decisions further solidified Jeffrey's expectation that the case regarding his parents was closed. He had the 1995 outcome, the first inquest finding, and now 2 explicit decisions from the DPP confirming they wouldn't prosecute. This created a significant basis for him to believe the legal matters were concluded.
So what finally tipped the scales and led to charges being laid years later? What changed?
Around 2005, the NSW police reopened the case as a formal cold case review, led by Detective Hans Rupp. This reinvestigation involved a really comprehensive look at all the original material, but crucially, combined with leveraging advances in forensic science and technology that weren't available back in 93 or 95. They also actively sought out new information and witnesses.
And this review uncovered things missed or interpreted differently before?
Yes. They revisited witness statements, and a neighbor provided new details about the sounds and sights from the Gilham house on the night of the murders, potentially challenging aspects of Jeffrey's precise timeline. Fire investigators conducted a fresh analysis of the fire scene, suggesting patterns of ignition and spread that seemed inconsistent with Jeffrey's description of the fire, starting almost instantly after Christopher lit a match to his mother's body.
Leading to those fire experiments later.
Exactly. That analysis led to specific fire experiments being conducted later by Mr. Monday for the prosecution. Forensics also re-examined bloodstain patterns and, crucially, retested the carbon monoxide levels in the victim's blood, using more advanced techniques than were available initially.
And what about the intercom? That became significant, didn't it?
It did. That was another key finding during the cold case review. Investigators discovered what appeared to be a bloody fingerprint or mark on the upstairs intercom unit. This mark had somehow been missed or wasn't noted in the initial investigation.
And its significance.
Its existence seemed to support a specific detail in Jeffrey's original account: his mother frantically calling for help via the intercom, potentially while bleeding. Now, while its provenance could be debated, did it get there during the attack or later? It did seem to corroborate a specific part of the narrative that placed his mother using the intercom during the events. It was a detail that was kind of hard to reconcile with Christopher being the sole attacker upstairs from the outset. It added complexity.
So these re-examinations and new perspectives on the evidence, while not necessarily proving guilt outright, were compelling enough to make the DPP revisit the case yet again.
Exactly. Based on the strength of the cold case review findings, particularly the reevaluation of forensic evidence like the CO levels, the fire patterns, and witness accounts, the Director of Public Prosecutions decided to proceed. In February 2006, nearly 13 years after the killings, the DPP filed an ex officio indictment directly in the Supreme Court, charging Jeffrey Gilham with the murder of his parents, Stephen and Helen Gilham.
A huge step, overriding the previous decisions.
A dramatic step. The Crown, represented by the Solicitor for Public Prosecutions, was now formally accusing Jeffrey of killing his parents.
And Jeffrey's legal team, with Paladin Law, PDLTD instructing barristers P. Bolton SC and S. Buchan, immediately mounted a fierce challenge to stop the trial before it could even begin.
Yes. In September 2006, they filed an application for a permanent stay of proceedings. This motion became a major legal battleground, forcing the courts to confront fundamental principles of fairness and the limits of the justice system.
What were their main arguments for stopping the trial?
They presented 3 primary arguments. First, they argued it was oppressive due to the extreme delay over 13 years since the events. The prejudice to Jeffrey was immense, they argued, citing faded memories and, crucially, the loss of key physical evidence from the scene over the years.
What kind of evidence was lost?
Things like Christopher's shave coat, fingernail scrapings, the actual knife found near Christopher's body, carpet samples, the intercom unit itself, and a set of keys. They're either missing or their evidentiary integrity compromised. They argue Jeffrey had reasonably moved on with his life, relying on the 1995 outcome and the subsequent DPP decisions not to prosecute, and that bringing charges now was unfairly prejudicial.
Okay, delay and prejudice. What was the second core argument?
It focused on the inconsistency with the 1995 outcome. They argued that allowing a trial now Seeking a finding that Jeffrey killed his parents would be inconsistent with the basis of the 1995 manslaughter plea, which, remember, was accepted on the premise of provocation because Christopher had killed the parents.
So even if not strictly double jeopardy.
Right. While not strict legal double jeopardy, as he wasn't tried for the parents' murders in 1995, they argued it undermined the earlier legal process and the first coroner's finding, bringing the administration of justice into disrepute. They invoked principles like incontrovertibility or issue estoppel, citing previous case law where courts had refused to allow facts previously decided in a judicial forum to be relitigated or contradicted.
And the third argument?
Simply that bringing a prosecution after multiple prior decisions not to was vexatious and oppressive, constituting an abuse of the court's process.
These arguments were complex, forcing the courts to weigh competing public interests, weren't they?
Absolutely. They had to consider the traditional rule against double jeopardy: can you be tried again after being acquitted of the same offense? Here, it wasn't the same offense, but the argument was about the underlying factual premise that was accepted, or at least not disproven, in the 1995 proceedings. They grappled with the scope of the court's inherent power to stay proceedings to prevent an abusive process, balancing the accused's right to finality and a fair trial, especially after a long delay and loss of evidence, against the community's strong interest in seeing those accused of the most serious crimes brought to justice.
And there was that context of the double jeopardy law reforms around that time, too.
Yes, that's worth noting. NSW had recently reformed its double jeopardy laws in 2006 to allow retrials for very serious offenses where there was fresh and compelling evidence. Now, Gilham wasn't a strict retrial for the same offense, but this legal reform signaled a legislative and potentially judicial shift towards allowing revisited prosecutions in exceptional circumstances involving serious crime. It was part of the background atmosphere.
Justice Howie heard the permanent stay application in March 2007. What was his ruling?
Justice Howie refused to grant the stay. He acknowledged the significant delay and the prejudice caused by lost evidence, but he determined that these issues could potentially be managed during the trial itself.
Wow.
He felt that through careful judicial directions to the jury, for example, instructing them about the missing evidence and reminding them of the high burden on the Crown to prove guilt beyond reasonable doubt, excluding any reasonable alternative hypothesis, fairness could still be achieved. He also noted that Jeffrey's detailed ERSP preserved his version of events, which the defense could use.
And on the legal challenge regarding the 1995 outcome, how did he view that?
Justice Howie was very clear on this. He stated the 1995 plea to manslaughter was not a jury acquittal of the murder charges for either Christopher or the parents. Jeffrey was never in jeopardy of being convicted for his parents' murders in that proceeding.
So the Crown's acceptance of the plea wasn't a binding factual finding.
That was his view. The acceptance of the manslaughter plea was simply the Crown acknowledging, for the purpose of that specific charge against Christopher's death, that they couldn't disprove the provocation claim based on the evidence at that specific time. It wasn't a judicial finding of fact that Christopher killed the parents. Therefore, there was no legal double jeopardy issue preventing the Crown from now charging him with the murder of his parents.
And the argument that it was simply oppressive to prosecute after multiple previous decisions not to.
Justice Howie found that it was not an abusive process for the DPP to revisit the case based on new evidence, given the gravity of the crimes. The public interest in prosecuting murder, he concluded, outweighed the arguments for a stay.
Jeffrey's legal team, still with P. Bolton SC and S. Buchan, appealed Justice Howie's decision to the NSW Court of Criminal Appeal. This was a significant legal event, heard by an enlarged bench of 5 judges, including Chief Justice James Spiegelman, reflecting the complexity. Barrister L. Babb SC appeared for the Crown, with N. Noman later joining the Crown team.
Yes. The defense reiterated their arguments about delay, prejudice, inconsistency, and abusive process. It was a major showdown on these principles. But the appellate court, in November 2007, upheld Justice Howie's ruling.
They agreed with his reasoning.
Essentially, yes. They agreed that the 1995 plea deal was not an acquittal on the merits for the parents' deaths, and that, legally, Jeffrey had not been in jeopardy for those specific murders in the 1995 proceedings. While one of the judges acknowledged it might feel like denying Jeffrey the full benefit of his earlier outcome, the court found no legal barrier to the new charge. Chief Justice Spiegelman was unequivocal in his separate judgment, stating there was no relevant inconsistency or double jeopardy at all.
So the public interest argument won out again.
Pretty much. The earlier conviction for manslaughter of Christopher did not legally prevent the prosecution for the murder of the parents. The public interest in prosecuting serious crimes, particularly murder, was seen as paramount, and the court was not prepared to grant a permanent stay.
Jeffrey made one final attempt to stop the trial, applying to the High Court of Australia for special leave to appeal in February 2008.
And the High Court refused to grant leave. That was the definitive end of the procedural challenges to bringing the case to trial. After years of legal battles, reviews, and challenges, Jeffrey Gilham would finally face trial for the murder of his parents, nearly 15 years after their deaths. Tony Gilham's relentless pursuit had, in effect, succeeded in getting the case back before the courts.
With the legal hurdles to bringing the case to trial overcome, the focus shifted to the courtroom itself. Pre-trial rulings were made by Justice Howie in early 2008, including on the admissibility of Jeffrey's key electronically recorded interview and the walkthrough video. As mentioned earlier, defense counsel P. Bolton, SC, and S. Buchan, arguing against Crown prosecutors Mark Tedeschi, QC, and K. Shedd, challenged their admissibility, citing the technical illegalities during Jeffrey's detention.
And as we discussed, Justice Howie, while acknowledging the technical breach, ruled against excluding them. He found the illegality unintentional and that it didn't unfairly impact Jeffrey, who seemed willing to cooperate. He weighed the high probative value of the interview, which contained Jeffrey's full account, essential for his defense against the prejudice from the technical breach, and deemed it admissible. This meant Jeffrey's own words from 1993 would be a central piece of evidence presented to the jury.
The first murder trial for the parents' deaths began in late 2008, with Mark Tedeschi, QC, leading the Crown prosecution against defense barristers P. Bolton, SC, and S. Buchan.
Right. The Crown's case was built on the theory of cold-blooded family annihilation by Jeffrey, followed by staging the scene. They presented evidence, focusing on forensic patterns, including similarities in the stab wounds on all three victims, to argue for a single perpetrator. They also explored a potential motive, touching on greed related to the family finances, although this motive was later downplayed in the second trial.
And the outcome of that first trial?
That first trial was complex, involving extensive evidence and expert testimony, and it ultimately resulted in a hung jury. The jury was unable to reach a unanimous or majority verdict.
So after all that legal wrangling to get to trial, they had to go through the entire process again. The second murder trial commenced in October 2008, again before Justice Howie. This time, Margaret Kunn led the prosecution, and the defense was represented by C. Stern, SC, and P. Barham, with Paladin Law PD Ltd. Still as solicitors.
Yes. The second trial benefited from the first in terms of evidence rulings and streamlined presentation, but the core conflict remained. Kunn adopted a slightly refined strategy. She placed less emphasis on specific motives like greed and instead intensely focused on demonstrating the impossibility of Jeffrey's detailed timeline based on the physical evidence. She also pushed the argument for the forensic unity of the killings, arguing that the wound patterns strongly suggested one person killed all three.
What were the key pieces of evidence presented by the Crown in the second trial to support their theory?
Well, a range of evidence was put forward to challenge Jeffrey's account and point to him as the killer. The bloody mark on the intercom was discussed. While the defense used it to support Jeffrey's account of his mother calling for help, the Crown could raise questions about its timing or relevance, trying to muddy the waters.
And the fire evidence.
The fire evidence, including Mr. Monday's experiments showing flame spread, was presented again. The Crown used this to argue the fire started relatively slowly, suggesting Jeffrey had time to attempt to help his parents rather than immediately confronting Christopher, thereby contradicting his narrative.
But there were issues with those experiments.
Big issues. And Justice Howie rightly cautioned the jury about their limitations. They weren't conducted on identical materials or with bodies present, stating they offered only limited assistance. That's a crucial direction for the jury to weigh, and a reminder for lawyers about the care needed with experimental evidence.
And the wound patterns, which the Crown used to argue for a single killer, that was central.
Yes, this was a significant part of their circumstantial case. Crown experts, including Dr. Calla and Dr. Culliford, testified about similarities in the number, location, and characteristics of the stab wounds on all three victims. They argued these similarities strongly indicated a single perpetrator, suggesting a single frenzied attack by Jeffrey.
But the judge limited how far they could go with that opinion.
Correct. The judge limited experts from giving an opinion on the ultimate issue of who committed the act. That's the jury's job. But he allowed evidence on the similarity of the wounds. The Crown then used that similarity evidence to build their argument that one person, Jeffrey, killed everyone. This use of expert wound analysis became a major point of contention later on appeal.
The carbon monoxide evidence also seemed critical to the Crown's timeline, didn't it?
It did, very much so. Dr. Lawrence, the Crown expert in forensic pathology, testified that Christopher's carbon monoxide level was low, 6%. The Crown argued this, suggesting Christopher was dead before inhaling significant smoke and therefore likely died before the fire started.
Which directly contradicts Jeffrey's story.
Exactly. It would contradict Jeffrey's claim that Christopher started the fire after killing the parents. However, under cross-examination, Dr. Lawrence did concede that a 6% level only indicated Christopher hadn't inhaled a significant amount of smoke, not definitively that he was dead before the fire began or hadn't inhaled any smoke. So there was some nuance there, but the initial testimony was powerful for the Crown's timeline.
Evidence about Jeffrey's demeanor and actions after the fire was also presented.
Yes, the prosecution highlighted the relatively minimal amount of blood found on Jeffrey, suggesting he might have cleaned up. His wet hair was noted, implying he might have showered to wash off blood, which could contradict his timeline of events. Witness accounts about his state were presented, some describing him as composed rather than distraught, contrasting with what might be expected.
And the firefighter's testimony?
The testimony of firefighter Officer Pelham, who claimed Jeffrey warned them, "Don't go down there, someone's got a knife," as they arrived, was used by the Crown to suggest Jeffrey was trying to prevent firefighters from entering quickly, potentially to allow the fire to destroy evidence.
And specific details from Jeffrey's story were directly challenged through other witnesses. They tried to pick apart his narrative piece by piece.
Absolutely. The Crown brought evidence intended to chip away at the credibility of details in Jeffrey's narrative. For example, Mr. Elton, a friend of Stephen Gilham, gave evidence suggesting Stephen would have used proper siphoning equipment for the boat, not a piece of garden hose, as Jeffrey claimed was used on the night. Professor O'Loughlin, an academic, gave evidence that Jeffrey's university project would not have required the syringes and tubing Jeffrey claimed to have used, potentially contradicting his explanation for possessing them.
Challenging his explanations for things found.
Right. Mrs. Moskos, who was at the Gilham house the evening before the murders, testified that she saw some tension, but no signs of the extreme aggression or psycho-behavior from Christopher that Jeffrey later described. The location of Jeffrey's keys near the front entrance was noted as potentially inconsistent with his claim of habitually locking his boat shed and taking his keys with him, a minor point perhaps, but one used to suggest discrepancies in his detailed account.
The source material also points to specific instances of the prosecutor's conduct during the second trial, led by Margaret Cunneen, that were later subject to scrutiny on appeal.
Yes, these instances became grounds for appeal, although their weight was debated. They included the physical use of the knife in court during cross-examination, which the defense argued was an irrelevant demonstration, ground 9. There were criticisms of the cross-examination style, described by the defense as improperly suggesting Jeffrey had set up his brother or showed disrespect by not knowing Christopher's exact date of birth, grounds 10, 12.
And the closing address.
Aspects of the closing address to the jury were also criticized, argued to undermine the judge's directions on the fire evidence or be otherwise improper, grounds 11, 12. It's important to note, as the appeal court did, that the defense did not object to these specific instances at the time, which is relevant under Rule 4 of the Criminal Appeal Rules when later arguing them on appeal.
So lack of objection at the time matters.
It does, but it still highlights the importance of courtroom conduct and its potential impact, even if an objection wasn't raised instantly. These things can add up in an appeal context.
After considering all the evidence and arguments in the second trial, the jury delivered its verdict.
Yes, the jury found Jeffrey Gilham guilty of the murder of his parents, Stephen and Helen Gilham.
And the sentence handed down by Justice Howie.
In February 2009, Justice Howie sentenced Jeffrey Gilham to life imprisonment for each murder, to be served concurrently. In his sentencing remarks, he described the offenses as being in the worst category, emphasizing their callous and brutal nature and the audacity of his plan to blame his quiet older brother, Christopher. He highlighted the profound revulsion felt by the community when a child kills their loving parents, a very strong condemnation.
But this was not the final chapter. Jeffrey Gilham, still maintaining his account of that night, appealed his conviction to the NSW Court of Criminal Appeal in 2012. Paladin Law Play Ltd. remained the solicitors, instructing barristers C. Stern SC and P. Barham, while the Crown was represented by L. Babb SC and N. Noman.
Exactly. And this appeal is arguably where the most significant cautionary lessons for barristers crystallize. Many grounds were raised, including that the verdict was unreasonable or unsupported by the evidence, that there were errors in admitting evidence, that there was improper prosecutorial conduct, and crucially, that new evidence existed which should lead to the conviction being overturned.
The unreasonable verdict argument is a complex one in circumstantial cases, correct? How does that work?
It is complex. In a case built entirely on circumstantial evidence, like the Crown's case against Jeffrey for his parents' murders, the prosecution has a very high bar. They must convince the jury not only that the evidence is consistent with guilt, but also that it is inconsistent with any other reasonable hypothesis other than guilt. This is the principle from cases like Barca.
And the appeal court doesn't just accept the jury's view.
No, they don't just defer. As per cases like M v. the Queen, the appellate court conducts its own independent assessment of the totality of the evidence, its sufficiency and quality, to determine whether, despite the jury's verdict, it is dangerous in all the circumstances to allow the verdict of guilty to stand. They look at the evidence holistically to see if that high standard for a circumstantial case was truly met by the prosecution.
And in Gilham's case, the appeal court ultimately found that miscarriages of justice had occurred, leading them to overturn the conviction. What were the key reasons?
Yes, they pointed to several issues, but two stood out as particularly significant, and together led to the verdict being quashed. The first was identified as a major prosecutorial failing: the Crown's handling of evidence from Professor Cordner.
Right, the expert on wound patterns. What was the issue there?
Professor Cordner was an expert in forensic pathology called by the defense. His expert opinion, which he had expressed previously and maintained, directly contradicted a core premise of the Crown's case. While Crown experts suggested the similarity and clustering of stab wounds on all three victims strongly indicated a single perpetrator in a frenzied attack by Jeffrey, Professor Cordner held the opinion that clustered stab wounds do not necessarily indicate a single killer.
So, a direct conflict with the Crown's theory.
A direct conflict. This was crucial evidence potentially undermining a central plank of the Crown's circumstantial case. The critical issue, highlighted by the appeal court, was that the Crown was aware of Professor Cordner's opinion, but failed to call him as a witness at trial or make him adequately available to the defense.
Why is that such a serious matter for the prosecution? What's the obligation?
Because it's a fundamental breach of the prosecutor's ethical duty. A prosecutor's role is not merely to secure convictions, but to ensure justice is done. This includes an absolute obligation to disclose all relevant evidence to the defense, including evidence that might not support the Crown's case or could assist the defense. By failing to present or make readily available expert opinion that directly challenged their own expert evidence on a critical point, like wound patterns, the Crown deprived the jury of a balanced perspective.
So the jury didn't get the full picture on that evidence.
Exactly. The appeal court found this failure constituted a miscarriage of justice because the jury was left with only the Crown expert's view on a contentious point, without hearing the contrary expert opinion that could have raised reasonable doubt about their single killer theory. It's a huge lesson about disclosure and fairness.
The second major factor was new evidence presented during the appeal regarding the carbon monoxide levels.
Yes, this was also critical. Professor Penny, a highly credentialed expert in carbon monoxide toxicology, provided new evidence during the appeal process. His analysis directly contradicted the Crown expert's testimony at trial regarding Christopher's CO levels.
What did Professor Penny find?
Professor Penny's opinion was that Christopher's carbon monoxide levels, and potentially his parents', were actually above normal and indicated significant smoke inhalation. He opined that Christopher likely inhaled smoke for 2 to 4 minutes, meaning he was alive and breathing smoke after the fire started, and was probably located upstairs in the vicinity of the fire when the fire began or shortly after.
How did this new expert evidence impact the case? It seems to turn the Crown's timeline on its head.
It really does. This was deemed new and compelling evidence by the appeal court. It directly contradicted the Crown's theory at trial that Christopher died downstairs before the fire started and never went upstairs. Professor Penny's analysis supported a timeline where Christopher was alive upstairs and exposed to smoke, which is actually consistent with parts of Jeffrey's original account, like his mother potentially calling from upstairs during the fire, while Christopher was also up there.
So this evidence alone could have changed the verdict.
The appeal court found that this evidence alone was capable of raising a reasonable doubt for a jury. It was a substantial reason the conviction was overturned. It shows how advances in science or different expert interpretations, even years later, can fundamentally shift a case.
The appeal court also revisited the admissibility of the fire evidence and the criticisms of prosecutorial conduct during the trial. What did they say about those?
Yes, they did. Regarding the fire experiments by Mr. Monday, the court agreed that they had significant limitations due to insufficient replication of the scene's conditions, different flooring, lack of bodies, and should likely not have been admitted. However, They concluded that this issue, while valid, wasn't as central to causing a miscarriage of justice as the issues with Professor Cordner and Professor Penny's evidence, particularly because the trial judge had already given the jury directions about the fire evidence's limitations.
And the conduct issues.
Concerning the criticisms of prosecutorial conduct, the court noted instances like the knife demonstration and aspects of the closing address were improper. However, they also observed again that the defense hadn't objected to these specific instances at the time, which, under Rule 4 of the Criminal Appeal Rules, can limit their weight on appeal. So, while noted, the failure to call Professor Cordner remained the more significant ethical breach, leading to the finding of a miscarriage of justice. Other alleged new evidence, such as the bloody intercom mark and alibi evidence based on lecture timetables, was reviewed but deemed not sufficiently new or compelling on its own to overturn the verdict, as it could potentially have been obtained or explored earlier by the defense.
So, based primarily on the combination of the Crown's failure regarding Professor Cordner's evidence and the compelling new evidence from Professor Penny about carbon monoxide levels, the NSW Court of Criminal Appeal quashed Jeffrey Gilham's conviction.
That's right. The guilty verdict was overturned. But then came the next critical decision for the court. Having quashed the conviction, should they order a third trial for Jeffrey Gilham, or should he simply be released?
That's an enormous decision, balancing deeply held principles. What factors did they consider?
It is a huge decision. The court had to balance competing public interests. On one hand, the immense gravity of the crimes, the murder of two people, and the strong public interest in seeing those accused of such horrific acts brought to justice and, if guilty, held accountable.
And on the other hand?
On the other hand, they had to consider the passage of time, which by this point was nearly 19 years since the events occurred. The loss of crucial physical evidence from the scene over those years was significant. The shave coat, fingernail scrapings, the knife, carpet samples, the intercom, the keys, much of it was gone, or its integrity compromised, making a fair trial much harder.
The practical difficulties of a trial after so long.
Exactly. There was the potential for further prejudice to the accused in facing a third trial after so long, with faded witness memories. The Crown's case would also be significantly impacted. They would now have to contend with Professor Penny's evidence about Christopher's CO levels and the possibility he was alive upstairs during the fire, evidence that aligned in part with Jeffrey's own original account. And finally, there was the history of previous decisions by the DPP not to prosecute. All these factors had to be weighed.
What did the appeal court ultimately decide regarding a third trial?
The Court of Criminal Appeal ultimately decided not to order a new trial itself. Instead, recognizing the complex balancing act required and the practical challenges, they left the decision of whether or not to pursue a third prosecution of Jeffrey Gilham for the murder of his parents to the Director of Public Prosecutions.
So they punted it to the DPP?
Essentially, yes. They stated that the DPP was in the best position to weigh all the factors: the feasibility of a trial after such a long delay in loss's evidence, the potential for prejudice to the accused, the strength of the available evidence, including having to account for Professor Penny's findings, and the public interest.
And the DPP's final decision was?
The Director of Public Prosecutions ultimately decided not to proceed with a third trial.
So Jeffrey Gilham was released?
Correct. After 2 decades, multiple investigations, legal battles up to the High Court, 2 trials, and a successful appeal that overturned his conviction, Jeffrey Gilham was released from custody.
So after all that, we are left without a definitive judicial finding from a jury as to who killed Stephen and Helen Gilham, other than the overturned verdict against Jeffrey. The legal system exhausted its avenues, ultimately unable to secure a lasting conviction under the high standard required for serious crimes, particularly after so long and with the issues raised on appeal.
Exactly. And this is precisely why the Gilham case is not just a tragic true crime story, but a profound, almost mandatory, cautionary tale for anyone entering the legal profession, especially those who aspire to be barristers, on either side of the courtroom.
What are the absolute key takeaways for aspiring barristers from this case? Let's crystallize those.
Okay, the most critical lesson, perhaps, is the absolute non-negotiable importance of prosecutorial integrity and duty. The failure to disclose, or worse, fail to call, Professor Cordner's evidence on wound patterns, which directly challenged a core part of the Crown's theory, was a central reason the conviction was overturned.
The duty to justice over winning.
Precisely. This is a stark reminder that a prosecutor's duty is to serve justice, not simply to win. It means an unwavering obligation to disclose all relevant evidence, even if it's unfavorable to your case, as set out in the prosecution guidelines. Aggressive tactics that appellate judges might later view as Impermissibly straining for conviction can be subject to criticism and form grounds for appeal, potentially contributing to a finding of miscarriage of justice. Your integrity is the bedrock of your role.
It also highlights the critical and sometimes challenging role of expert evidence.
Absolutely. The Gilham case shows that lawyers must be deeply familiar with the expert evidence in their case. You need to understand its scientific basis, its limitations like those fire experiments with poor replication, and be prepared to challenge it robustly in court.
And be aware that science evolves.
Yes, you also need to be aware that expert understanding can evolve, as shown by Professor Penny's carbon monoxide analysis years later, which fundamentally altered a key piece of evidence. You must be prepared to seek out your own experts and ensure their evidence is sound and properly presented. Don't just accept expert opinions at face value. Scrutinize them.
The case also touches on the complex and sometimes shifting nature of principles like double jeopardy and the concept of finality in legal proceedings.
Yes, Gilham demonstrates that even when there isn't strict legal double jeopardy, as he wasn't acquitted of the parents' murders in 1995, the law and its interpretation can be tested. The 2006 reforms show a willingness in the legal landscape to revisit serious crimes with fresh and compelling evidence. Defense lawyers, even when securing a favorable outcome like a plea bargain, must advise clients that for the most serious crimes, that outcome might not be an absolute unchallengeable shield forever, particularly if genuinely new and compelling evidence or perspectives emerge.
Finality versus the pursuit of truth.
It's a constant tension. The concept of finality is crucial for the justice system. But in exceptional cases involving grave crimes, it can be complexly balanced against the pursuit of justice, especially when new information comes to light.
And the practical realities of extreme delay are on full display here.
Immense. The nearly two-decade gap between the crime and the final decision highlights the profound prejudice caused by long delays. Memories fade, and crucial physical evidence can be lost or degraded. Lawyers on both sides must be acutely aware of this. Defense lawyers will argue this prejudice strenuously, potentially seeking a permanent stay. Prosecutors must navigate presenting a case years later while ensuring fairness to the accused, perhaps by seeking specific judicial directions to the jury to mitigate the impact of lost evidence, as Justice Howie did.
Finally, trial conduct itself. Does it always need an objection?
While not the sole reason for overturning the verdict here, aspects of the prosecutor's conduct during the second trial were criticized on appeal. This reinforces that professional and ethical conduct in the courtroom is paramount. While failure to object at the time can limit the weight of these points on appeal, as we noted with Rule 4, they can still be noted and contribute to the overall picture considered by the court. Maintaining professionalism matters.
So we've taken a deep dive into the Jeffrey Gilham case, tracing the story from that horrific night in 1993 through 2 decades of investigation, intense legal battles over procedural rights, 2 dramatic trials, a successful appeal that hinged on issues of expert evidence and prosecutorial duty, and ultimately a decision not to retry.
It is, without question, a compulsory case study for anyone in law. It vividly illustrates the ethical burden on prosecutors, the critical need to rigorously examine all evidence, especially expert testimony, the practical challenges posed by time and lost evidence, and the complex, sometimes difficult balancing act between achieving finality in legal proceedings and the ongoing pursuit of truth and justice.
The Gilham case ultimately leaves us with unsettling questions. After so many years, so many investigations, and so many legal battles, with the conviction overturned based on fundamental issues of evidence and process, the legal system never definitively resolved who killed Stephen and Helen Gilham for a jury.
No final answer from the courts on that core question.
What does the ultimate inability to secure a lasting verdict, whether conviction or acquittal on all charges, say about the limits of our adversarial system in resolving the most horrific crimes, especially when fundamental questions about how evidence was handled, expert opinions were presented, and ethical duties were discharged are raised years, even decades down the line?
It's a profound question. It forces us to consider the system's fallibility, the impact of human error, the challenges of uncovering truth after so much time has passed, and the weight of ensuring fairness even when faced with terrible crimes.
It's a case that continues to echo in courtrooms and law schools, a stark reminder of the fallibility inherent in the human pursuit of justice.